Walt Nauta's trial is now scheduled right alongside Donald Trump's. That's going to be in August of 2023, which is very, very soon. And we are curious as to whether this trial will actually happen. I think it's probably a long shot. But what we see here is that Judge Cannon issued an omnibus order. Now that Walt Nauta, Trump's personal assistant and valet, has been arraigned, there is a second set of instructions that have come out for the court. And Walt's team is going to be complying with this. And it looks like trial has been confirmed for very soon. Now, Trump's team is going to file a bunch of responses. Walt's team is going to do the same. But you see here, this is the most recent from the court, 6 pages. It is an omnibus order setting the trial date and establishing, once again, pretrial instructions and sentencing proceedings. And this is coming fast. Remember, we've got a bunch of documents, classified security clearances that they're going to be having to jump through to get people to review this stuff. And so we're expecting, even special counsel wanted this thing to go back to December, but Trump's team has hasn't agreed to that. And so as it stands, trial is still scheduled for 2 weeks, commencing on August 14th with a calendar call to be held in August 8th. It's like 30 days from now, man. All hearings are going to be held in Florida. Modifications to be made necessary as this matter proceeds. They say any testing of any of your electronic equipment must take place prior to the calendar call, and all pretrial motions must be due by July 24th, 2023. And we often here spend a lot of time on these motions in limine because they're so much fun. They are efforts to exclude evidence, exclude witnesses. We remember in the Proud Boys trial, the defense wanted to talk about all of these government undercover informants. And of course, they filed motions to talk about it, and the government filed motions to exclude it. So we want to talk about all this stuff. But those motions are going to be due very quick. Now, in reality, I actually think these things are going to be extended very far. But it's just amazing that we're holding these dates right now. Absent leave of the court, each party is limited to filing one motion in limine, meaning you get one argument, one motion filing, bound all your arguments in there together. Trump and Walt have to file their motions together unless there's a clear conflict of a position. Motions may not, without leave of the court, exceed the page limits. And it's further ordered that if you want subpoenas for witnesses, you got to get those going right now. It says the parties shall file speedy trial reports every 21 days, although we've got trial as now scheduled in about 6 weeks. All responses pursuant to the local rules must be introduced. Counsel shall be prepared to conduct a limited voir dire. So this is called jury selection. So let's say we fast forward and the calendar call is on August 8th and we have jury selection the following week. Lawyers shall be able to, and I think this is probably going to be the same rule, even if this is continued out. So they have limited voir dire prior to the calendar call. Each party may file no more than 10 proposed questions, including any subparts. So Trump's team will get 10 questions. Government gets 10 questions. The court will not permit the backstriking of jurors. Prior to the calendar call, the parties shall submit proposed jury instructions, including substantive changes in a proposed form. They don't need to agree on it, but where there are disagreements, they've got to cite to authority. The parties should identify the jury instructions, and prior to the calendar calls, I want all of our exhibits marked into evidence. I want a list of all proposed witnesses. The government labels theirs GX1, defense labels theirs DX2, and so on. And no later than the first day of trial, the government shall provide the court with a tabbed binder. The judge wants it in a 3-ring binder, all exhibits that were filed. If there's going to be a change of plea, it has to happen soon, prior to 5 p.m. on the last business day before trial scheduled to begin, so probably on a Friday. Any motions for a continuance of the trial, which I fully expect we'll see. Jack Smith has already filed one, but Trump has not responded to that yet. If you want to continue this out, these are the methodologies by which you can do it. Set forth in your motion the following: details which constitute grounds for continuance under the law, including the complexity of the case, which I think is massive, the security clearance process, the anticipated impact of the Classified Information Procedures Act. In other words, all this stuff is not going to be done in the next 6 weeks. And indicate whether the reasons served by granting the continuance outweigh the defendant's constitutional and statutory rights to a speedy trial. And we often talk about the right to a speedy trial. I don't imagine that Trump is going to ride that hard right now, because I think his interests are also served by extending this out, pushing it past the election. If Trump wins the election, or when, then he is able to come out and pardon himself on all of these charges, and the whole thing goes away. They say that the filing by counsel of a notice of unavailability by motion must follow the local rules. If any party wants to introduce transcripts, do it prior to the calendar call. All anticipated Jenks Act material, which is discovery, these are documents that the government relies upon in their case, shall be turned over to the defense counsel no later than the morning of the first day of trial. The material shall include a face sheet acknowledging receipt, and for the purposes must be filed by the government no later than a certain period after the trial. The court parties are notifying the court if an interpreter is required. Follow the local rules in your filings, including with exhibits. If this matter proceeds to sentencing, if they're convicted, we'll deal with that later. The court has discretion to not consider untimely objections, and if you're looking for upward and downward departures, submit those in writing. So, this is the Omnibus Order signed by Judge Eileen Cannon, U.S. District Judge. And the big takeaway on this is that we are still on schedule right now, as of now, for trial next month, man! In August 8th, a calendar call, and August 14th, an actual trial date. So, as I said, I fully expect these to move and be postponed. Even the government doesn't want this thing to happen up until December. And so Trump's team will respond. And because this is such a complicated case, this fast track path is, I don't think, something that's going to stand. We've got all of these things that they're going to need to comply with. Security clearance process, I think that they're going to be challenging each individual document and the categorization of each document. This is classified, not classified. This is a presidential record. This is not a presidential record. And I hope they also make the bigger argument, which is that every single one of those documents is the product of the executive branch creating or demanding documents to do their job, and those are documents that are possessed by the executive, and they're therefore Trump's documents. And I think that there's strong argument that's founded in the Constitution to support that. So this is the omnibus filing. We know that there is going to be a motions deadline by July 24th. Otherwise, trial is scheduled. Trump's team will file motions responding to the government's continuance, and we will continue to follow, see what trial looks like. Thank you, my friends, for subscribing wherever it is you're watching this, and we'll see you as this case unfolds.